Welcome back to New Money. We're discussing estate planning this evening. My guests are Harry Joffe and Dr. Mervyn Messias. If you'd like to email, you can always send your email and query to info@anchorcapital.co.za. Harry, deal with the story about letters, power of attorney, because so many people believe a power of attorney is from the date given to the death of the individual. That's not the case. And also the concept of getting curatorship. I've got a person at the moment who's been told they've got a life policy for a person suffering from Alzheimer's. They can get no information whatsoever. Please take us through this, Harry.
Yeah, Bryan, I mean, it's really a big problem now in South Africa because, unlike the UK, we don't have a concept of what we call an enduring power of attorney. In other words, we still apply the old agency principle, which means if you create a power of attorney, that power of attorney is only valid so long as the person who signed it has their mental capacity. The minute they lose their mental capacities and they don't appreciate that power of attorney anymore, that power of attorney ends in our law. Now, Mervyn will know, he's been on this a lot longer than me. Mervyn will know that the Law Society has been asking for over 20 years now. There's been a request to change South African law by way of legislation. And I know, Mervyn, the Law Society, you were involved in that estate. You were in charge of the estate planning and the estate duty section there, has asked Parliament and put together draft legislation, but nothing's come of it. So, Bryan, we now sit with our common law, which is exactly as I said, the minute you lose your mental capacity, that power of attorney ends. We've got a lot of heartbreaking cases where we've had a case now where an individual had an investment with us. That individual's in an old aged home and they've lost their mental capacity. Their child has got a power of attorney. The child wanted to cash in the investment to pay the fees at the old aged home. But of course, the child has got no capacity to act because the power of attorney is invalid. And we had serious problems there trying to help the client. So, Bryan, they've got three options. The first one is, as you said, is to apply for curatorship, which is not a cheap process and it's not a simple process. You have to apply to court, you have to bring, doctors and all of that, and you have to give expert evidence. That's the first option. And we find a lot of our clients just can't afford that. Second option is to apply for what we call from the master for an administration letter. Now, in some cases, we've got that. If their estates are small, typically if the estates are below R1 million, and I'm not sure exactly what the amount is in the legislation, but if it's below R1 million, the master will give you an administration letter, and that will allow the child or the close family member to at least administer that asset temporarily. And then the third option, of course, is what Mervyn was saying. If you've got an individual who's lost their mental capacity, and you can get them in a lucid moment, and of course most of them will have lucid moments, you can get them in those lucid moments to transfer their assets to a trust, of course signed off by the doctor and the lawyer that they were lucid when they did that sign off. And then the assets, of course, sit in a trust, and they can be administered by the trustees, and you don't have any more issues with powers of attorneys and curatorship. The first prize is when you have an individual and you can start seeing their capacity going, is to create the trust and transfer assets into the trust, no doubt about that. And then, of course, you're even going to get certain tax benefits in the trust because it's for an individual with a disability. But Bryan, if you're sitting with that power of attorney, we have endless trouble with it, I can tell you. And your issue you raised about information, it's the same issue because remember, the owner of the policy has got the right to the information. The power of attorney is no longer valid. So for us to give information to some other family member is very dangerous for us as an insurer. We've had cases with divorces where they're divorcing their spouses want information, and then we get dragged into litigation. And so it's a big problem to try and get information with a power of attorney if it's no longer valid.
Mervyn?
So, Bryan, how tricky this issue is in practice.
Okay. Mervyn, any quick comments before I get on to our emails?
Yes, a simple comment is that I'm determined to change the law in South Africa.
Bless you, Mervyn.
Well, Mervyn, why is it taking 20 years? Why is it taking 20 years?
What Harry's saying is 100% correct. It is absolutely absurd in South Africa that we don't have the enduring power of attorney, which almost all the first world countries have. It's an absolute lacuna in our law that you can't basically appoint your own person to act for you if you are mentally disturbed or if you are physically incapable of managing your affairs, that you choose a person who you trust to deal with those matters instead of a court appointing that person. And it's simple. There's a simple process for it to happen. Not only is it for your financial affairs, but your actual physical well-being. If you need medical treatment, there should be a process to appoint the person you choose, your own doctor, for example, and not have the doctor on duty or some relative decide for you. So those things have to be addressed, and I intend to do that.
Well, I hope so.
Mervyn, you'll be doing a great service. Bryan, sorry, and I think the point to stress here, Bryan, in South Africa, I mean, most South Africans, as you know, they can't afford a court process. You can afford to go to court, to get a curator appointed, go through the whole rigmarole of doing that. If Mervyn can get that law changed, so it's a simple, cheap power of attorney, which isn't a costly exercise at all, you'll be doing a great service. And particularly, Merv, with so many South Africans now with dementia on the rise, with an aging population, this is a huge social imperative.
Okay, so let me ask this question. Most institutions, do they even follow up to see if the person who's got a power of attorney is whether the person giving it is still capable, or do they just?
Bryan, we do. I can tell you, Bryan, we do very, very strictly, and we even have in our investment company people that phone the client, and I talk to them over the phone every year to check that they still compass. We're very strict on that, because else we can get dragged into litigation and we can be responsible. You know, if an investment is cashed in and the person cashing it in didn't have the correct authority, we are potentially liable. So I can tell you we are incredibly strict on that.
And tell me, Mervyn, a question regarding beneficiaries. If I've got the power of attorney for an individual and I act on that and the institution doesn't pick up that that individual is incapable, could beneficiaries hold me responsible for actions I've taken?
Yes, it could be fraud, in fact. It would be fraud if you act knowingly that, is that what you're referring to?
Yeah.
That you know the individual is incapable.
Yes, yes.
Yeah, that would be fraud. In South Africa, that would be fraud. You don't have authority once the individual is mentally incapable.
Well, I hope our viewers take this into account, because many people do have power of attorneys and they don't, and maybe not realizing that that power of attorney comes to end. I want to get into some emails. Stuart in Mshlanga, I'm going to give this one to you, Harry. Under the voluntary disclosure program, where I'm allowed in my tax return to disclose previously unreported income, are there any penalties and do I pay interest?
Well, Bryan, that's a very tricky question to answer just off the cuff. I'm not sure which program is referring to. Is it the 2003 amnesty? Is it the later amnesty?
No, no, there is under your tax return voluntary disclosure program. It's
not one of the older ones, because they
no, set, no, just on the year, every year you can disclose undeclared income previously, as long as you're not being investigated, and the individual is just asking, do I pay penalties and interest?
So you definitely pay interest. You'll definitely pay interest. The penalties is a tricky issue. I mean, you have to negotiate with SARS on the rate and all of that. But interest you definitely pay.
Okay, I'll deal with that. Mervyn, Ian in Randburg says, I'm retiring and taking 1/3 of my retirement policy in cash. It's quite substantial and there's a lot of tax to pay. If this is added to my other assets and I die shortly thereafter, will this cash, which I've already paid tax on, also attract estate duty, either 20 or 25%?
He would probably, this is more your game, but I would have thought he'd go for an annuity. If he's going to take out the cash, he certainly will be liable for estate duty.
So someone taking their cash and dying 6 months later, this cash now will form part of their estate and they'll be dutiable again.
Well, Bryan, so just to jump in, Mervyn's correct. If you've got two options, of course, when you mature.
But Harry, this question is not about the pension. This question is where someone's taken cash, paid the tax up to a maximum of 36%, and then going further, saying now it's part of my estate. Let's say it's 5 million, and that's now added to my.
Bryan. I mean, Bryan, why wouldn't it be subject to estate duty? Let's look at a simple scenario. I earn a salary every month. I pay tax on my salary at 45%. It's now cash sitting in my bank account. If heaven forbid something happens to me, I'll still pay estate duty on that. Of course, the proviso there, Bryan, is if you bequeath it to your spouse, you get the 4Q deduction. If your estate is less than 3.5 million, you get the 3.5 million rebate. But in principle, there's no reason why, if you paid income tax on something, you shouldn't pay estate duty if that's your asset. The two taxes are not related.
So
Mervyn gave very good advice, actually. If the client converts it into an annuity, annuities are free of estate duty. But if he's got a lump sum, that's estate dutiable.
Okay. Then Leonard in Westcliff says, my mum has had a stroke and she's given me power of attorney. I've instructed the insurers to make some changes to investment portfolio. They've made the changes. However, I understand that because of my mum's incapacity, they should not have accepted this. If in time it's discovered, will my request become invalid, particularly if my brother and sister object? Mervyn?
Well, my question is this. Would she have had mental capacity at that time? If she hasn't got mental capacity, then the power of attorney would be ineffective.
And any changes made, as we spoke about, you used the word fraud, I don't think they'd be saying that one of the kids is fraudulent, but it could be overturned.
Could be overturned, and it might not only fraud, but it can be theft as well.
Yeah.
And Bryan, there could be litigation. I mean, it could easily have one of the heirs suing that person for making that change if it's cost their money. So, for example, we've had these cases. Say that we invested in a certain fund, and this the query was that they cashed out of that fund. Now, the other heirs who weren't responsible for that decision can say, as Mervyn said, that power of attorney is invalid. You've taken a decision which has prejudiced us, and they could sue them. Could definitely be litigation.
Okay, well, look, I think this is a hot potato that many of our viewers need to digest. But estate planning may be very simple, but in some cases the process involves the realignment of all of one's assets and how these are used during one's lifetime and ultimately to the benefit of the beneficiaries. We all know the following saying, where there's a will, there's a way. In estate planning, this is not true. It's where there's a will, there's a relative. Planning one's estate does not take a lot of time, but without this, it could have a major impact on your beneficiaries. Harry and Mervyn, thank you for joining me this evening. It's important to note that our program tonight is to provide information and should not be construed as advice. Next week's program, we'll be dealing with investments, and if you need to get hold of me, my details will appear on the screen. I'd like to thank you for watching, and good night.